Hello, welcome to the videos for Seminar 6 of LW 109. In the last few videos, we've talked a lot about the concepts of tenure and estates, and we've talked about what it means to own land. And you should be familiar by now with the idea that, for our purposes, we need to recognize that a person doesn't own land itself. We need to be able to differentiate instead between the estates and the interests in land that a person owns. Because different estates and different interests entitle a person to do different things with a particular plot of land. And these estates and interests are the essential building blocks upon which land law is constructed. But a further fundamental aspect of property law is the impact of equity. Now, as you well know, land law and equity in trusts are standalone modules, but they're also foundational to the understanding of property rights. And in this week's videos, I'm going to talk about the foundations of equitable property rights. Next week, I'll introduce the trust, which is possibly the most important invention of the courts of equity. But first, it's worth spending a bit of time recapping some of the key points from the last couple of weeks so that we can look at these foundations of equitable property rights. So, as you now know, substantial legislation in 1925 was introduced that still shapes modern land law. And a feature of the doctrine of estates was that it allowed for the fragmentation of ownership rights amongst various people. So it's quite possible for a multiplicity of estates to exist simultaneously with respect to the same plot of land. So you could have a plot of land owned by one person, while another person has an equitable interest in the same land by virtue of contributing money to the purchase of it. And then you might have another situation where a further person, perhaps a neighbour, has a right of way over the property. These all should be ideas that you're becoming a bit more familiar with now. And Section 1 of the Law of Property Act 1925 reduced the number of legal estates that could exist to two: the fee simple absolute in possession and the term of years absolute. But then there's also a key distinction between legal estates and legal interests. And the distinction between estates and interests is important because the concept of an estate indicates ownership rights in land, which are possessory in nature, whereas the idea of an interest in land generally means rights over another person's land. So you need to note the distinction between legal estates and legal interests. And one of the things that the Law of Property Act 1925 did was to reduce the number of legal interests that combined a purchaser. But then also, and a key point for this week, is that since the Law of Property Act 1925, all other estates in land can now only exist in equity. So, I'm going to recap this point. I've already mentioned that the only legal estates capable of existing are the fee simple absolute in possession and the term of years absolute. Various interests are then capable of taking effect as legal interests in land, and they're defined by Section 1, subsection 2 of the Law of Property Act 1925. The most important of these legal interests are easements and charges by way of legal mortgage, but we've also talked about things like profits. An easement for an interest equivalent to a fee simple absolute in possession is capable of taking effect as a legal interest, And similarly, a mortgage is one of the most important interests affecting land and can also take effect as a legal interest. But if a property right doesn't fall within the closed list set out in Section 1, Subsection 1, or Section 1, Subsection 2 of the Law of Property Act 1925, it can't be a legal right. And it must therefore be an equitable interest. And Section 1, Subsection 3 of the 1925 Act confirms this and tells us that all other interests can only exist as equitable interests. But why does this matter? What is an equitable interest? To understand the concept of an equitable interest, we need to think about the historical basis of equity. And this means a journey through the foundation of English law, because the English legal system has gone through a series of developments. And one of these is the development of equity. And to understand this, you need to spend a bit of time getting to grips with the way the English legal system looked in the Middle Ages. And in particular, you need to understand the emergence of the common law and the Court of Chancery. So, read parts 1 and 2 of the seminar notes and the section readings mentioned there, which discuss the origins of equity.